All rise.
Court is now in session.
May it please this honorable court, based on the three stated claims, we have few counter arguments to be made. We will counter every single claim accordingly. First and foremost, in regards to the first claim, my lord, that the court hears not the most expert opinions, but those most favorable to the respective parties. And partisan experts frequently appear for one side. Based on the statement, it can be divided into two parts. The first part is the court hears not the most expert opinions, but those most favorable to the respective party. Whereas the second part is partisan experts frequently appear for one side. We will rely heavily on the case of Pembinaan Teroris Sepakat Sendirian Berhad and Kumpulan Ikram Sendirian Berhad and another. 2050, 10 MLJ 764 to rebut the first claim. For the first part, we argue that there is no requirement that the opinion given by the expert must be the best or the most expert. I refer my lordship to the case of Pembinaan Teroris Sepakat Sendirian Berhad that it was held that the court is not required to opt for the most expert witness, but where there is conflicting expert testimony, the court has the discretion to prefer one opinion over another. The approach to evaluating the conflicting experts' opinion is to examine the scientific grounds and basis on which they rely. Based on this authority, we assert that there is no requirement for a court to opt for the most expert witness in that particular field. My lord, we would like to also highlight that any expert opinion is acceptable by the court so long as the evidence given by the expert is within his expertise. This principle is best illustrated in Genting Highlands Berhad and another, and GM Aero Support Sendirian Berhad and another. 2022, 1 NLS 252, where the court held that although an expert is referred to as someone with special skill, he needs not to be so by special study. He may be so by experience, and that is why even a semi-skilled or semi-professional person may qualify as an expert witness. My lord, it must be highlighted that in Chiu Yi-Hui and Tan Siu Ni, 2020, 1 NLS 136, the High Court ruled that a fundamental aspect of the evidence of an expert witness is the ground on which he has formed his opinion. This is prescribed by Section 51 of the Evidence Act, my lord. The section reads, whenever the opinion of any living person is relevant, the grounds on which his opinion is based are also relevant. The necessity to provide the grounds of opinion was also emphasized by the Court of Appeal in Junaidi Bambang against PP, 2011, 3 CRJ 484. Next, we would like to draw the attention of the court to the case of Sim Ah Song against Rex, 1951, 1 MLJ 150, where the court held that unless the expert witness gives an explanation which supplies the understanding of the subject which the court lacks, the court is in no better position than it was before to determine the question which it is its duty to determine. And if the court acts upon a bare expression of the expert's opinion, the determination of the question becomes that of the expert and not of the court. Hence, we argue that when the experts are required to provide the grounds of opinion, they are prevented providing a bare expression or explanation that will cite either party. Also, my lord, the principle established in the case of public prosecutor against Sharafi bin Abu, 2018, 9 MLJ 352 was in line with our argument. In this case, the court stated that in evaluating expert witnesses, it was not a contest of who was the better expert. It was a question of whose findings or opinion was the preferred one. The primary function of an expert was to assist the court, given the expert's field of expertise that a judge may not possess. In short, we assert that the court neither hears the most expert opinion nor those favorable to the respective parties, but evaluates the expert's evidence before reaching a decision.
My lord, moving on for the second part of the first claim, partisan experts frequently appear on one side. It is undeniable that it is reasonable and correct statement, since the choice of the word did not connote the situation. So the expert witness will definitely give the testimony they sided with the party who called him to testify. My lord, it is our argument that if a party call a partisan expert, that party need to bear its consequences. In the case of Pembinaan Teroris Sepakat Sendirian Berhad, the expert witness who was somewhat partisan was called by the party and he provided simplistic testimony. The court then ruled that it was not convinced by his expert opinion. In this respect, we argue that expert witnesses should be independent in giving their expert opinion. Nonetheless, by virtue of Datuk Dr. V, Turai Singham and other, and Samakan Anak Lelaki Kanapati and other, 2016, 3 MLJ 227, my lord, we argue that a partisan witness is not unreliable witness if his findings are based not only on his research, but more on research done by other person whom he has quoted extensively. On top of that, the evidence by a partisan witness can be accepted and be considered if the opposite party did not produce an expert of their own to dispute the finding and opinion of the partisan witness. In other words, the opposing party is always entitled to challenge the evidence given by the partisan witness. This principle is affirmed in the case of UMW, Toyota Motors Berhad, and other, and Alan Chong Tek King and other, 2021, 3 MLJ 107.
Moving on to the second claim, in which the statement experts are paid for their services and instructed by one party only, some bias is inevitable and corruption a possibility. My lord, on this claim, it can also be divided into two parts. In the first part, experts are paid for their services and instructed by one party only, and in the second part, some bias is inevitable and corruption a possibility. For the first part, it is our contention that not only one party can call for experts to assist the court in arriving at a just decision. Order 40A of the Rules of Court 2012 clearly indicates that the parties are free to call any expert witness to give evidence. This provision alone is sufficient to rebut the assertion that experts are instructed by one party only.
Moving on to the second part, my lord, we do not deny the facts of some bias is inevitable and corruption a possibility. However, we contend that the expert must know his duty to the court according to Order 40A-2 Clause 1 of the Rule of Court 2012, whereby it is their duty to assist the court on matters within his expertise. This provision is illustrated in the case of Batu Kemas Industries Berhad and Kerajaan Malaysia Tenaga Nasional Berhad 2015 5 MLJ 52, in which the court held that it is the primary duty of an expert to assist the court in arriving at the right decision, even if he compromised the case of the party who called him and is paying for his services. On top of that, the evidence of an expert should not only be independent, but should be seen to be independent. It's pertinent to add that the opinion of experts are relevant facts only insofar as they can assist the court in forming an opinion upon the issues in the case pursuant to Section 45 Clause 1 of the Evidence Act 1950. As an independent heir to the court, it is therefore essential that an expert witness must possess and retain a standard of absolute personal integrity. Additionally, an expert witness' overall duty is to provide independent, impartial, and unbiased evidence to the court, which is stipulated in Order 40A, Rule 2, Clause 2 of ROC 2012, which can be clearly seen in the case of Ubalan Anak Lelaki Berebal against Pendakwa Raya 2020 MLJU 1187. It must be taken note that the expert witness is called by one party does not detract from the overriding duty to the court. Next, my lord, we argue that an experienced and vigilant trial judge is able to combat the issue of bias. In this context, the experienced trial judge is able to evaluate the appropriate weight of the evidence and in assessing the authenticity and motivation of the experts. The judge has the discretion to consider any expert evidence coming before the court, and where necessary to direct that little weight be given to an expert's evidence, or in some cases, strike out at the expert testimony entirely. I refer my lordship to a case of Dato Mokhtar bin Hashim and other against public prosecutor 1983 2 MLJ 232, in which in the case of a witness who is not skilled, the judge will decide that his evidence be disregarded. According to the instant case, it's also held that the evidence of expert is nearly always a weak type of evidence and is to be received with caution. This is because human judgment is fallible and human knowledge is limited and imperfect. Moreover, it's not uncommon that an expert witness, however impartial he may wish to be, is likely to be unconsciously prejudiced in favor of the side which called him. This is the area of caution that the court must always bear in mind in assessing the evidence of an expert. In short, my lord, we conclude that an experienced and vigilant judge can play an important role in determining the admissibility and the weight of the expert opinion. Besides, we further argue that the opposing party is perfectly entitled to challenge the evidence of the plaintiff's expert witness by way of cross-examination without him having to call his own expert. This principle has been clearly illustrated in the case of UMW, Toyota Motors Berhad, another, and Alan Chong Tek King and another, which is above mentioned. On the strength of the foregoing authorities, it is permissible in law for one party to rebut its adversary case by cross-examining the opponent's expert witness. This is an essential safeguard to ensure the quality and reliability of evidence. By doing so, the evidence given by a biased expert witness will be detected and his evidence will be excluded by the judge. In addition, the court in Term Dynamics Berhad lawan Kerajaan Malaysia 2018 1 LS 342 observed that under Rule of Court 2012, there are two types of witnesses, which are court expert and expert of parties. In order to tackle the issue of bias and corruption practice by the expert parties, the court can appoint a court expert by virtue of Order 40 Rule 1 of the ROC 2012. Sir Thomas Bigham in FD National Mortgage PLC and Key Surveyor National Limited Liability 1996 3 All England Law Reports 184 held that the court expert with no axe to grind but a clear obligation to make a careful and objective valuation may prove a reliable and source of expert opinion. Next is Dyer, Kao Tara Singh and Mayan Banking Berhad 2018 1S 700. The court held that in appointing a court expert would have been mindful of the rationale behind such appointment. The court made reference to the Malaysian Civil Procedure 2015 edition, Volume 1, page 504, which succinctly commented on the basis of the appointment of the court expert as follows. The order also serves to prevent the court from being left without expert assistance in cases where the experts of the parties have given entirely contradictory evidence on technical or scientific questions. With that being said, it's clear that a court expert will definitely solve the problem of bias and corruption asserted by the report.
My lord, moving on to the third claim, in which the statement where a substantial disagreement concerning a field of expertise arises, it is irrational to ask a judge to resolve it. The judge has no criteria by which to evaluate the opinion. In regards to this claim, we contend that the judge has the right to solve the issue and evaluate the opinion when conflicting opinions from the experts arise. This argument has been clearly illustrated in the case of Batu Kemas Industri Sdn Berhad and Kerajaan Malaysia Tenaga Nasional Berhad above mentioned. The court in the instant case held that when expert opinions are in conflict with one another, the court is obliged to assess the evidence and accept, if necessary, the most reliable parts in forming its decision. In this respect, the court may put relevant questions to the expert for the purpose of clarification or eliciting further information. The argument that the judge is the one who solved the issue of conflicting expert opinion is also supported by the case of Majuikan Sdn Berhad and BALQIS Bank PIC 2015 1 MLJ 171. In the present case, the court cited that where there are conflicting expert opinions, the judge is of course entitled to bring to bear his own judicial appreciation of the matter and choose one over the other, but where there is only one expert opinion, he should not as a rule reject the opinion outright without judiciously considering whether it is obviously indefensible and unsupported by the basic facts of the case. Also, citing the principle derived from the case of Zul Hasnima Binti Hassan Basri and others, and Dr. Kupu Welmani P and others, 2016 3 MLJ 625, the opinions of the expert are a question of fact, and there is nothing wrong with the learned judge's preference of one expert opinion over the other if she can reasonably explain the preference. In other words, the judge is obliged to solve the issue when conflicting expert opinions arise, and it is rational for the judge to do so. Other than that, my lord, in the case of Ong Chanto and R 1963 MLJ 160, Singapore High Court through Winslow J held that experts should not be asked to give conclusions on matters which eminently matter for the court to decide. In the case of Chin and Wah and PP 1958 24 MLJ 154, the High Court decided that the ultimate decision on any issue is with the court. Thus, we argue it is crystal clear that the conclusion or any decision on any issue is made by the court but not by any expert witness.
In conclusion, my lord, the claims from the report were not correctly alleged based on the above-mentioned counter-arguments. There are principles and duties that need to be upheld and practiced by the court and also the expert witness. The mechanisms provided in the statutes serve as a guarantee to the parties in arriving at the right decision. Most importantly, the discretion to accept the expert opinion still lies within the hand of the judge. Thus, my lord, expert opinion can be relied on in establishing the case.
Much obliged.